Justice of the Appellate Department. Hear ye. All persons have a present duty before this court. Go out there and give their attendance and they shall be heard.
Good morning. Please be seated. The first case for oral argument this morning is People versus Byron Johnson.
Good morning, Your Honors. May it please the Court. Danielle Wild appearing on behalf of Brian Johnson. Brian Johnson's trial turned on one question. Did he possess a loaded firearm in Four Brothers Tavern on April 4th, 2015? There being no eyewitness testimony, the jury's sole task was to watch the video footage, interpret it, and answer that question. But they were deprived of that opportunity, and Brian Johnson was deprived of a fair trial because the lead investigator was allowed to do the jury's task for them.
Was there any objection?
There was not, and this issue is unpreserved. But because of the nature of the testimony was so critical, it was really the people's only evidence in this case. The court should reach this issue in the interest of justice. But even if it doesn't...
Ms. Wild?
Yes.
Good morning.
Good morning.
Not only is it was not preserved, but also defense counsel and the prosecution stipulated to the admissibility of Exhibits 93 and 94, both of the videos, correct?
Yes, that's correct. The video itself was stipulated into evidence.
And you're not objecting to that on appeal because it would effectively be waived by the consent to it. And if I understand it correctly, the first issue in your brief has to do with the identification of the defendant, correct, in terms of the subset?
Yep, that was sub 1.
Now, that's really not an issue because, as the people point out in their brief and as evident by the opening statement, is it that defense counsel opened and said, basically, yeah, you're going to find him in the video. He's in the red outfit. There's going to be no mistaking him. So the identification is really not an issue vis-a-vis Mosley, is it?
So the initial identification itself is certainly not the critical issue in this case, but the fact that Investigator Klein effectively said 18 times that Brian Johnson was the perpetrator and 3 times that he possessed a gun is the critical issue. Certainly the entire...
The officer basically identified the gun for him, didn't he?
3 times, Your Honor. 3 times Investigator Klein unequivocally stated that Brian Johnson had a gun.
What was the alternative as well? And let me throw out a couple options and you can pick another one.
Sure.
But it seems to me if the video is going to be played for the jury. It's stipulated in evidence. Is it the people's obligation? Is the prosecutor supposed to stop the video and say, jurors, look at this? Do they have to have a witness to say, look at this? Do they have to simply not do anything, play it in real time, and let the jury effectively guess as to whether or not there's a weapon there, which could be a cell phone, for example? See, Mosley doesn't answer all these questions for us. That is, once it's in evidence, what can the people do with it? I think they would argue that they can use it to aid the jury's understanding of the crime that the defendant is alleged to have committed. Otherwise, the video is not relevant unless it shows a weapon, at least from the people's perspective. How do you handle that?
Sure, Judge, I don't think this court needs to necessarily articulate the full scope of what they are and are not allowed to do, but certainly the court can draw the line and say that the investigator who was not an eyewitness to the incident should not be permitted to interpret all ambiguous mannerisms and movements of the defendant as it appears in the video, and certainly should not be able to testify that that metallic object is a gun 3 times.
So should the jury be left to guess as to whether or not they see a weapon, or should they hear the people's perspective and what they think the video proves, but then leave it to the ultimate determination of the jury?
The latter, because certainly the people can argue in their closing argument, which is not evidence, that the metallic object was a gun, just as the defense attorney would argue that the metallic object was a cell phone, and the jury should be the ones to resolve that question.
This is what's troubling me, and I don't think we have all the answers, and forgive me for drilling down on this, but it's interesting. It comes up in a lot of cases with the surveillance videos that we have. But see, there I have an issue because I could see how the defendant would object to say, Your Honor, The identification of this glint of steel, this weapon in a defendant's possession, whatever, is not part of the proof. No one testified to that, so the people cannot argue it in closing. Isn't that the real problem here? And that's why I'm trying to say, if the officer was allowed to testify, where did he cross the line? I'm really struggling with this. I'm sorry to vent it all out.
Sure.
But it's an issue.
So perhaps if the lead investigator stopped at, you can see a metallic object there, that would have been certainly less problematic
But he
than.
did much more than that. And
He did much more than that, Your Honor.
The prosecutor, we're talking about frame at 1 hour and 43 minutes and 3 seconds, I believe it is. And the prosecutor even paused the surveillance video at that point at one time. And the officer said, you can see the actual top of the handgun or silver portion of a handgun extending from his right hand. Rewound it again. And the officer indicated the significance of this portion of the video in response to the question from the prosecutor was, again, I see Brian Johnson's arm as it's coming into the light out of the shadows. He's pointing. His right hand is holding an object and has a rounded silver back, a rounded metallic back to it. He's holding it in a fashion, really in a manner. The only thing you could hold, it would be a handgun.
Well, Your Honor, you just made my argument for me. Perhaps I could sit down.
Oh, they paused again, too, didn't they?
They did.
143, and indicated the same individual in the lower right-hand corner, Brian Johnson. His right hand now is coming up perpendicularly, again, to his body, and the light is just glistening off the top. I use the word glinting, I'm sorry, glinting off the top slide or the top portion of the handgun, the metallic handgun. It's the only thing illuminated in that video at that time. And again, this is coming from an officer, right? A police officer.
Yep, the lead
who
investigator.
Maybe have portrayed to the jurors that, even though they're probably instructed beforehand, you're going to hear testimony from a police officer, the testimony is the same, you have to give it any more weight. But, this is the police officer who's saying, that's a handgun. Look, it's the only thing it can be is a handgun. So
Correct.
And he's charged with possession of a handgun.
Correct. And Investigator Klein wasn't
Do you have
the,
anything further?
perhaps not on this point, Judge, but certainly,
Well, taking you to the second point, on the
Yes.
effectiveness of counsel, it seems to me, with all these clear issues that are articulated as to why the defendant should have objected, for crying out loud. It seems to me your point one goes hand in hand with point two.
Absolutely.
I don't think you can find in favor of the defendant on point one without also finding point two, correct? On ineffectiveness.
I agree with that. I think the people actually said it best in their brief when they wrote that the lack of discussion on the record about the propriety of this testimony is directly owed to lack of preservation, and the defendant could have charted a different course by objecting to the testimony's foundation or requesting voir dire, or certainly objecting the first time, the second time, the third time that investigator or client unequivocally testified that there was a gun.
To be clear, you would say we really can't find in your favor in point one without also finding in your favor in point two ineffectiveness, correct?
I think that's true. I think there's absolutely no legitimate strategy that would justify an attorney failing to object in this case, particularly when his entire theory of the case and strategy was to convince the jury that the metallic object was a cell phone and not a gun. So allowing the investigator to testify 3 times that the metallic object was a gun is contrary to his entire strategy.
Counselor, your point is that it's not clearly a gun in the video.
Correct.
So if it was, he could testify, he presumably could testify, as you can see, jury, he's pulled out his gun, but it's not clearly a gun, it's a shiny metallic object.
I don't think I need to say that it would have been proper otherwise, but certainly it wasn't proper here for that very reason, because it did not unequivocally show it.
And why is this different than when we allow testimony, say about a drug house or something, certain activities outside of there, and the officer's allowed to use his experience saying these type of actions are indications of that, where he might say, I'm familiar with how somebody holds a gun, where they hide it, and that's really what he's opining on. Explain that in your position.
So I believe I addressed this a bit in my reply brief to the people. with the analogy to Inwa. Certainly, perhaps if Investigator Klein had stopped his testimony as people who have unholstered weapons typically make these kinds of movements, and then allowed the jury to, using that testimony and explanation, now watch the video and interpret it for themselves, that may have been proper. Certainly, it was less improper than the testimony in this case. But here, the issue is that Investigator Klein testified to the ultimate issue, which was whether he had a gun.
I think we have that argument.
I would just want to briefly address point 6 of the brief, that if the court does reverse this case and grant Mr. Johnson a new trial, as I believe it should be reassigned to a different justice, given the intemperate remarks and the rulings that the trial court made in this case.
One other thing, in the summation from the prosecutor, any
Yes.
references to Officer Klein's testimony?
I believe I put in a 3-page chart in my brief that lines up Investigator Klein's testimony with the prosecutor's summation that clearly is a visual that indicates that he truly was a summation witness, which was exactly what the Court of Appeals warned against in
But your
Inwa.
point is the prosecution could say those in closing, you just can't have the officer say it.
Correct.
Thank you.
Thank you.
Good morning, Your Honors. Ryan Ash for the people. I believe the identity of the defendant at the Four Brothers Tavern is ultimately a very central issue in this case, and this,
Wasn't it more essential for the murder charge too, which he was acquitted of?
right. And so this case being a complicated case that has 6 counts with 2 different shootings, the Four Brothers shooting was only relevant to count 6. It was a criminal possession count. The murder charges were a huge focus of the defense.
We're aware.
Yeah, it was a huge focus of the defense, though. And the defense did numerous things in this trial, strategy-wise, that charted their course. One of them being the defendant playing as peacekeeper. And I do agree that the defense attorney's actions about what to object to was a part of charting a course. Because here we have someone who was at the bar, was caught on video, not really caught, but like was on video at the bar being a patron and being involved in the scuffle. And the identity evidence of him wasn't disputed for obvious reasons and part of strategy. And the rest of the evidence in context surrounding Investigator Klein's testimony that that silver curved thing in his hand is a gun, they all lead to the conclusion
It's
that
the only
it's
thing it could be.
right. But I would agree with Investigator Klein because looking at the other evidence,
And that's not for the jury to determine.
it is for the jury to determine, and the jury is well within its right to disregard his testimony.
And again, none of this was preserved.
None of it was preserved, and while if we focus in on the lack of preservation for this one issue, it may look and seem extremely large, but this was the least severe count on a 6-count indictment where the defendant actually was acquitted of the murder counts. And I think when we look at the representation as a whole, we can see...
So what are you saying, is that he was a winner?
The defendant, at the end of the day, definitely didn't win the war, no. But definitely won several points, and several important points that were important to the defense counsel's strategy.
Well, on that point, Mr. Ash, with respect to strategy, again, I don't think the identification is an issue because it's very good video.
I agree.
The defendant happens to be wearing a very obvious outfit, bright red. So the identification is not an issue. So I can see there being a strategy. Don't bother going after that and objecting to that because it's coming in no matter what.
Right.
Second, on the qualifications of the officer, I can see not wanting the officer to testify to all his presumed qualifications, the classes he's taken, the experience he has in identifying movements. So that could be a strategy where defense counsel didn't object.
Right.
So, and then you just let it go, and then you argue the evidence to the jury, say, they didn't prove it beyond a reasonable doubt.
Right.
So that's a
And-
strategy too. So my question to Ms. Wild before about tying 1 and 2 together, the counter to 1 also is the counter to 2, correct?
Right, they're related issues, and I agree that the lack of preservation is the reason we don't know the answer to some of those issues. It's
We
not,
could have gotten the answer. If there had been-
we could have gotten it, but the, you know,
If there'd been an
that,
objection, we could
this
have.
is the reason for the preservation requirement, and raising
Yeah.
those in the context of ineffective assistance doesn't automatically turn one argument into another argument. I think the court's familiar with the rest of my points, and I'll rest on my brief. Thank you.
Thank you. 854, People versus Christopher Kirky.
Thank you. May it please the court, James Eckert for Christopher Kirky. First issue I'd like to argue is ineffective assistance
I'm
of
sorry,
counsel.
pardon me?
Pardon me?
I'm sorry, I didn't hear you.
The first point I'd like to argue is ineffective assistance of counsel, particularly counsel's failure to counter the people's offer of DNA evidence as though it was probative of who was driving the car. There was a DNA sample found with 2 contributors, one of whom was Mr. Kirky. It's his car. That's not a surprise. Everyone acknowledged that. But the second was another male contributor who was not Mr. Shute, who was the only other male in the car. And therefore, the DNA, so far as we know when it came from either before or after the accident, because that other man was not in the automobile at the time of the accident. So therefore, the DNA was virtually irrelevant. The prosecution doesn't have to stop proving connection between Mr. Kirky and his car. So it's not irrelevant in the sense that it can be prevented from being introduced to the jury, but in terms of probative value for who was operating the automobile, and Mr. Kirky was found outside of the car, and particularly important was, it's clear that he was wearing a seatbelt. The DA argued at page 719 that his injuries were consistent with him wearing a seatbelt. She said it was the driver's seatbelt.
There were 2 male occupants of the vehicle.
Correct.
And the dominant DNA that was found was the defendant.
Correct.
And the other was excluded, wasn't he?
Correct. And the prosecution presented that as though, obviously, it means Mr. Kirky is driving. But no, what it means is the other male contributor came from a time that was either before or after the accident. So this one DNA sample that's mixed came from, to the extent that we know when it was placed on the steering wheel, came from a time other than the accident. Because there was no second male in the car.
But if you tie that in with who actually was in the vehicle, why is that relevant?
Well, my point is that the DNA is not relevant to who was driving the vehicle, and yet the prosecution presented it as triumphant proof that Mr. Shute was excluded, and that was improper.
Okay, I think we have that argument, too.
Yeah, and the important thing here, because this is a very triable case, Mr. Kirky was wearing a seatbelt. He said he was wearing a seatbelt. The DA concedes, I think it's 719 that he's wearing a seatbelt, tries to argue that and the black box that was critical to the people's proof about the operation of the car, it was going 119 miles an hour, the brake was put down, said the driver was not wearing a seatbelt. And if that's the case, and Mr. Kirky is wearing a seatbelt, and he's found outside the car, and additionally, counsel was ineffective for failing to object to the denial of a defective summation. The one thing that he did to bring out an important fact was ask the doctor whether the injuries of Mr. Shute were consistent with airbag industries, and the doctor's answer, page 633, was they could possibly be associated with an airbag, but not necessarily. Consistent is a pretty weak argument in all cases. It just means this fact doesn't disprove this other thing. It could be true. And the doctor's testimony is sort of yes, but it certainly allows counsel to make the argument that the airbag injuries were consistent, Mr. Schute's injuries were consistent with the deployment of an airbag, and then instead of arguing these being denied a chance to give an effective summation, counsel just apologizes. Failed to object to prosecutorial misconduct. The DA at one point says The absence of Mr. Schutz's DNA on the steering wheel means he's excluded as having, he didn't touch the steering wheel, which is just completely uncalled for. And the people point out on appeal that the second time they said that, they didn't repeat that part of it, but I think if you
We'll
watch.
look at that.
Yeah, if you watch, it's just a callback. They didn't withdraw it. And the result could well have been different here.
Anything further?
I think also it was an insufficient inquiry into Mr. Kirky's complaints about counsel's failure to investigate and so on. This is an awfully, one officer testified, this is a rural part of Wayne County. This is an awfully crowded area to have that many cars. And Mr. Kirky specifically pointed out people who were present in the car and so on. And although it wasn't, people were present at the steaming that weren't questioned about their possible involvement.
Okay, I think we
although-
understand all that.
And I would rely on my brief for the remaining points. Thank you.
Good morning, Your Honors. Michael Tantillo for the respondent. The first thing I want to do is just address one comment that counsel just made, in which he said it's clear that the defendant wore a seatbelt.
Yeah,
I would submit that
I was going to ask that question of you. It seems to me that there's equivocal testimony regarding the seatbelt. Is that correct?
Equivocal, certainly, at the very least. The only evidence that the defendant was wearing a seatbelt is the defendant's own statement to the first responder, I was wearing a seatbelt. At the same time, he had also said to a first responder, there were no other occupants in the car, which was incorrect, and I don't know who was driving the car. So either he was intentionally making false statements or he was so confused that he didn't know what the real situation was. That's the only evidence in the case that the defendant was wearing a seatbelt. I think it's pretty clear that he actually was not wearing a seatbelt. The DNA evidence in the case was really only a relatively tangential piece of evidence. The most important evidence in the case is, of course, the fact that the defendant was observed 10 minutes before the crash getting into the car, the driver's seat, the victim climbing into the back seat of the two-door vehicle, and the defendant peeling out of the gas station at a high rate of speed and then crashing the car with 2 fatalities 10 minutes later, 10 miles away.
And it's his car.
Pardon me?
It's his car.
It's his car.
And there's
He owns the
testimony
car.
that he didn't let other people drive the car.
Whether it's let other people drive or let other people borrow the car, clearly that was testified to. The victim, Michael Schutz's brother, also testified that his brother, the victim, Michael Schutz, did not have a license and didn't drive a motor vehicle. So there's abundant evidence that the defendant was the driver of the vehicle, and the key evidence is, of course, the videotape and the crash 10 minutes later with the car being operated at 115 miles per hour.
And the injuries also, the expert medical testimony was consistent.
My
with
very
him
next
being-
point, Your Honor, that's correct. There were 4 accident reconstructionists who actually testified in this case, and there was testimony that the rear seat passenger, because the crash occurred on the right front quarter panel of the vehicle, the occupants would have been impelled forward and to the right, and a rear seat passenger would have sustained injuries to his right side. Michael Schutz had massive injuries to his right side from his head down to his legs, with virtually no injuries to his left side. At the same time, the defendant had abrasions to the left side of his chest, and there was also expert testimony that the driver would have also been impelled to the right and would have collided with the steering wheel. There was enough force, as you can see, that the steering wheel was actually bent and deformed, and the defendant had abrasions and bruises on the left side of his chest consistent with that. So I would simply submit that the evidence is very clear. Certainly it would be objectively unreasonable to suggest that a different verdict would have been appropriate. And I'll just rest on my brief for the remainder of the issues.
Thank you.
Thank you very much.
855, People versus Luciano Pine Perilla. In just a second, we're going to wait for Mr. King. Good morning.
Good morning. May it please the court, Brad Keene for Mr. Pene Perilla. We would argue that the emergency exception did not apply to the search of the residence. The mere presence of narcotics without more is not an exigent circumstance. And here, the law enforcement was aware that appellant had been secured. The girlfriend was not present at the residence. There was no knowledge of anyone else there. No officer said that appellant sold drugs from that residence. And even if people were in the apartment, they would not know that appellant was in custody. There was no evidence that anyone knew anyone was in danger or anything like that. So it's important, I think, for this court
Mr. Keem, good morning, sir. Just fascinating case in terms of the first point that you're on right now is that one could argue, as you do here, that the entry by using the keys of the defendant's keys there to go in without knowing there might be somebody in there, without knowing about, the drugs haven't been tested, things like that. That all makes some sense to me, but where I'm hung up, and maybe you're going to get to it in your next point, is since no evidence was found as a result of that potentially illegal entry right then, and they purportedly then waited, an hour or so before they began the search, and no evidence was seized in that hour, according to anything in the record. It seems to be the only way you get to home base, so to speak, is by also showing that the court got the credibility of the officers who testified wrong, because we should believe that in fact there was a search going on before the warrant was obtained and they showed up with the warrant. Isn't that your point, is that we have to go the second step? Forgive the long question, but that's where I see you coming from, is that we can't just say, hey, that entry was unlawful because no evidence was seized, therefore defendant doesn't have any issue, but we have to then disbelieve the officers and believe the 19-year-old who testified.
I do, and initially I do think it's important that the court address the emergency exception, though, because that's what the trial court based its decision in part on, and I do think that was improper. But I do, in order to get to home base, to use your analogy, this court has to find that despite the hearing court's great weight accorded to its credibility determinations, that we have to believe the 19-year-old. And I think that there is a good reason to do that, because the record reflects that there's 5 officers standing in this residence for 2 hours, and they're supposedly not searching, but yet when they do search, they find contraband within minutes. Photographs are taken within 4 minutes. The record has some information that just doesn't seem right. It doesn't seem like these officers are just standing around in this apartment. And then the 19-year-old, he's saying that while he's handcuffed, he's seeing officers move, rummage through the apartment, slamming objects on the ground. And I think because he's 19 and he's not savvy to this process, the way that he describes it has credibility. He's talking about the officers saying bingo when they find something prior to the warrant. So I do recognize that the court is afforded great deference, but I think in this particular situation, this court has enough to find that the court lacked credibility.
Mr. Keem, just to go back to the point you made, if no evidence was seized purportedly as a result of the improper application of exigent circumstances or an emergency, why do you say that we have to opine on an issue or even address Osorio, whatever the case is that's cited by the people? Seems to me if we simply conclude one way or the other about credibility, that answers this issue. I'm intrigued by your statement that we should address that issue. I'm not sure that we should.
Well, so my understanding is that the court based its suppression issue on exigent circumstances. And perhaps I'm reading that wrong, but that was my impression. And that precedent in Onondaga County, in cases that may not ever reach this court, that exists, and I think that's problematic because there's no exigent circumstances here.
Okay, thank you.
Morning, Your Honors. Brad Osler for the people. I'd first note that I don't think there's anything in the record that would suggest that this court should second guess the credibility determination by the suppression court, especially in light of the fact that the only evidence that purportedly supports the defendant is the testimony of the 19-year-old.
Well,
And-
weren't there some photographs taken, I mean, to your point, some photographs
Yes.
taken when he had said that they had been smashing things and going through things, but if you look at the photograph, not everything's intact.
That's correct, and I think that's I think that's the end of the discussion, essentially. I think there was an entry photo at 9:44, if I'm not mistaken, and the apartment seems perfectly clean and in order.
What about 4 minutes or 5 minutes later? Wasn't there a photograph of a pillow having been cut open and drugs coming out of it? I thought that's sort of what the defendant was arguing, is that if you listen, if you accept the 19-year-old's testimony and then look at how quickly they found the drugs upon entry with a warrant, that just shows in human experience that they had to be searching around, and that corroborates the 19-year-old's testimony. Isn't that the counter to what you're saying?
It is, but I would push back in two ways. Number one being that I think it's probably fair to say these officers, as part of a drug task force here,
And there's
it's not
5 to 7 of them, right?
right. There were a number of them. It's not their first rodeo. I think they probably know some common places that drugs are hidden. I think I've watched a few movies where you cut open a couch cushion and it's inside. And if there were no entry photo, I suppose maybe I'd have some more concerns. But if the 19-year-old is to be believed, that entry photo is I don't know, false evidence, doctored something, and there's just nothing to suggest that that is the case.
Counselor, what about the first argument that there were no exigent circumstances because the officers didn't know that there was anyone inside the residence? And there was no reason for them to go in. They should have just applied for a warrant and then gone in.
I don't think there's any support in case precedent for a ruling that the officers are not allowed to essentially secure the scene, which is what they did. And given the nature of the investigation, there's drugs. It's easily destroyable, fungible evidence.
And that's their justification. They were saying we wanted to make sure there were no drugs destroyed. But the defense is arguing that they didn't know anyone was inside the residence, so who would have destroyed the drugs?
I know they don't know that there's anybody inside, but if we look at the factors by which we would analyze an entry like this or preservation of the scene, they all kind of support what the officers have done. To suggest that they can't go in to secure the scene or to make sure that there's nobody there, I think kind of overlooks a lot of the realities of this type of police work. I mean, it's just it's not a handgun. You can't flush a handgun, so to speak, but you can get rid of drugs down a sink or down a toilet or something like that.
I think that's Mr. Keem's concern, and I think maybe he's made a good point about in terms of if we let this stand in terms of exigent circumstances, because this is different in my view anyways, and I'm happy to hear your other view on Osorio. Osorio there was an informant as well. I think they had some probable cause to believe there was drugs or weapons, whatever, in the home. So it's different than here. Here, within moments, they take the keys out of his pocket and walk in. They've seen the girlfriend leave. It's her apartment. He's living there. There's nothing in the record that shows they have any reason to go in there at all, that there's any reason to suspect that the drugs will be destroyed at that moment. It seems to me leaving that sit there, Mr. Osler, is a little problematic. Isn't that a good point or no?
Well, let's take a brief look at what they found on him. I think it was something like 250 packets, something along those lines.
They hadn't tested it yet.
No. I'm not sure what it would be based on common experience, but that's strong evidence of sales. That's not personal use. That supports the reasonable inference that there's going to be some other evidence inside the apartment, possibly other drugs or cutting agents or whatever the case may be, that would support evidence of or provide evidence of sales, which is important. Then taking all of the factors, for instance, from the McBride Court of Appeals case, we have a Class B felony potentially. We have obviously an unquestioned association of the defendant with the premises that they were securing. They were able to make a peaceful entry, and based on what they saw, I think there's a clear clear expression of probable cause, which obviously they put into the warrant and then acquired that properly. All of those things, I think, justified the entry here. They didn't break the door down. They didn't have to climb in through a window. They didn't do anything that would sort of offend, I think, anybody's sense of privacy or reasonableness in terms of police action. Given the evidence they had in the entry that they were able to make just by using the key, I think that's certainly supports their ability to simply secure the scene and then just sit on it.
If they knew for a fact that no one was inside, would your view be different?
I think if they had some sort of interior surveillance and you knew nobody was in, yeah, I don't think there'd be any need to enter.
And then what if the key didn't work in the apartment? Where do you fall on that?
I think I'd be put in a more difficult position. Granted, they watched him exit the apartment, so we know, we still have that association. But given
But it gives him some ownership over the apartment.
it certainly does, and the peaceful entry, is one of the factors the courts have considered in terms of what is permissible. And in this circumstance, certainly they were able to do that. Thank you.
Thank you. 8:57 in the matter of Melanie M. Did I say it? I'm not sure.
I'm with you.
Good morning. You need to unmute yourself, please. There you go. Thanks.
Good morning, Your Honor.
Go ahead.
May it please the court, I'm Rebecca Constein of Counsel to the Legal Aid Bureau of Buffalo. I represent the subject children in this matter. I'm happy to rest on the brief and just answer any questions that the court may have and offer an update in regards to the children if the court wishes.
An update would be great with respect to the parties. That would be nice to hear.
Both children continue to do well. They remain placed together in the same foster home that they have been in for over 2 years at this point. They're well bonded with the foster parent, and just procedurally, at this point, they are freed for adoption.
And what about visitation? Has that been happening? Where's mom? Please.
So visitation was occurring. We did try and negotiate a conditional surrender on behalf of the mother. Unfortunately, she did not wish to go forward with that. We did proceed in a default posture, unfortunately. So she does not have visitation with the children going forward. The foster parent is still willing to do that, but there is no court order that is guaranteeing her visitation.
But just so that my notes are correct, you're saying that there's been an order freeing the children for adoption?
Yes, her rights have been terminated, Your Honor.
So she didn't show up for the hearing, right? It was a default, you said?
It was a default. She did leave the courtroom and did not participate in the hearing or go forward. She did have counsel present, but they sat silent and declined to participate.
Thank you. 8:59, Albert Ficola Jr. versus First Choice Realty, Inc. Okay.
May it please the court, Alexandria Twynham on behalf of respondent, the Honorable Randall B. Caldwell. I'm happy to answer any questions the court may have. Otherwise, respondent would rest on his brief.
Thank you. 861, New Wave Energy Corp. versus Energy Mark LLC, and Justice Montour is recused on this matter. Sorry. Good morning.
Good morning, Your Honor. Sorry for the delay there. May it please the court, Robert Knorr on behalf of the plaintiff, New Wave Energy. This case comes down to a pretty simple proposition, and that is whether or not the statements made by Mr. Claw were opinion or fact. And the court below analyzed those statements by saying all that Mr. Claw was trying to convey was that the clients were paying too much relative to what the utility would have charged. That's not all that Mr. Claw was saying. Mr. Claw very specifically said that New Wave were fleecing, that they were overcharging, And Mr. Claw in his deposition specifically acknowledged at page 1112 of the record that he expected the clients to read the article that he sent and come to the conclusion that they were being overcharged under their contract. That's very different than comparing to what would have happened had they had a different deal with the utility. And I note that Mr. Claw doesn't compare to Energy Mark, he compares to the utility. And the court below made a determination of what the purpose of an ESCO is. And using the court's determination of what a purpose of an ESCO is, the court determined that if the overall cost is higher with an ESCO than a public utility, one would be hard pressed to make the argument they weren't being fleeced. I don't know where that comes from in terms of the record. I don't know that there was much argument about the purpose of an ESCO, but that's what the court determined, was that they were being fleeced. I feel like the court below completely missed the point of Mr. Claw's statements being very much generated towards potential clients to make them believe that New Wave was acting immorally, was fleecing them, was scamming them. That's a very different thing than to say that it was Mr. Claw's opinion that the client could have paid less had they been with the utility. And I think this case comes down to that.
Counselor, just so I'm clear, there's 3 emails at issue, correct?
That's correct.
And you're objecting to all 3? You think he was liable in all 3? They're all defamatory?
Your Honor, clearly the email that uses the term fleeced.
Fleecing, right. Okay, and what about the other 2?
The other 2, we believe they talk about being overcharged.
Right.
And Mr. Claw in his deposition suggested that what he meant by overcharged was relative to the contract. And the information that Mr. Claw put out to the person receiving these statements wasn't anything to do with the contract. It was comparing what they might have gotten under the utility. Well, that's very different than saying you were overcharged, charged more than you were entitled to be charged under your contract. That's a false statement. It's a statement of fact because you could have compared to the contract, but he did not.
But isn't the way the email is worded what's important here as opposed to what he might have meant if it's somewhat ambiguous even?
Yeah, the language is clearly important in the defamation case, Your Honor. I agree with that. And that was my point, was he used the phrase overcharged. And in using that phrase overcharged, he was suggesting that they were being charged more than their contract. And
Okay,
in fact,
I think we have that argument. Thank you.
Thank you. Other than that, I will rely on my brief. I think that was the main point that the court below, we believe, missed in terms of determining this to be an opinion and not a statement of fact.
Thank you.
Thank you.
Good morning, Your Honors. Eric Kramer, colleague in law on behalf of Energy Mark and Kevin Clough, the respondents in this case. May it please the court. This case is about 3 emails to 2 people. And in both instances, the appellant did not lose the customer. That is clear, meaning there is no damages here. There's nothing defamatory in any of the emails, but only one of the emails uses what I'll call colorful language in the terminology fleecing. The lower court properly held, when presented with the case law from our summary judgment motion, that the word fleecing in the single email where they did not lose the customer was a hyperbolic statement of opinion, and that courts routinely find this non-actionable in these circumstances. Moreover, Mr. Clough provided factual information in the form of attachments with his emails. These are sales emails where Energy Mark is trying, or Clough here on behalf of Energy Mark is trying to get customers to switch to his company. New Wave gave testimony that they do the same thing. This is these are direct competitors for customers. And the courts of this state have held that even words like shakedown or labeling someone as a vampire, they're not actionable. And a word like shakedown is akin to fleecing, perhaps even worse. A shakedown implies some sort of scheme.
We understand what a shakedown is.
Yeah, okay. But, and I'm not splitting hairs, but I think that, those types of words are synonymous. And they're implying that, a person enters into a contract with an ESCO, an ESCO, they don't do it to pay more money, they do it to save money. So I think that providing a comparison to what they would have paid under just the utility, meaning like the rest of us who get bills from National Grid or National Fuel, instead of using an ESCO, they would have paid, in some cases, thousands of dollars less. And I think presenting them with that information in an attempt to get them to switch to Energy Mark is entirely in line with it being a sales email. And I would note that all 3 emails were unsuccessful in getting people, getting customers to switch from New Wave to Energy.
We understand that as well.
All right, and just based on the backup data provided, he's providing backup for his opinion. So whether we look at it as using hyperbolic language or an expression of pure opinion, in both cases, no matter which route you take, these emails are not actionable.
I think we understand your argument.
Other than that, I will rely on my brief, and I thank you all for your time.
Thank you. 863, Mario Saraiva versus New York State Thruway Authority.
Good morning, Your Honors. May it please the Court, my name is Daniel Schneider from the firm of Offit Kerman, and I represent Mario Saraiva in this matter. It is respectfully submitted that respondent won the trial below, not on its merits, but by convincing the court to exclude relevant and admissible evidence. As a result, a new trial should be ordered. There are several categories that are reversible error. Expert testimony that existed in a supplemental affidavit, which also the respondent opened the door. Expert testimony was unduly narrowed, exclusion of an accident report on the ground of remedial measures, but it was to be used for credibility purposes. And the question of credibility of a witness based on him living with appellant, being in the same union, coming from the same state, coming from the same country, despite the fact that the testimonies shows that they were not friends, and that's not controverted.
Counselor, is it fair to say, as I read your brief, and I don't want to steal your argument here,
No.
but you have identified what you consider to be a number of what I perceive to be evidentiary errors that were material, that is, they were important. And you say, based on those evidentiary errors with respect to the testimony of notice as to Mr. Benvenuti,
Yes.
with respect to Mr. Topsidis, with respect to the remedial measures, and third, the testimony of your expert was not allowed to get into the details of the voltage or amperage.
Correct.
You're saying the combination of those errors, those evidentiary errors, should get you a new trial?
100%, Justice Curran. Thank you. Thank you for that question. But I also will say that the notice, and I was just about to get into the most important one, which was the notice testimony that was precluded, and that alone should require a new trial. The combination absolutely should require a new trial, but the notice testimony that was precluded is dispositive, and that's and I'm asking the court to recognize the Mariani case from the Second Department in 2011, 83 AD 3rd, 669. A new trial was granted because late discovered notice testimony was precluded. The facts here mirror Mariani. There was a late elicitation of notice testimony. It is uncontroverted, and the judge found that it was unknown to the claimant, and both the testimony from Benvenuti regarding the other witnesses and the Sam incident, the second shock to Benvenuti.
Your point, as I understand it on that issue, is they could have easily deposed Benvenuti. They had his name, they had it since 2017 or thereabouts, and they should have deposed him, so any prejudice was non-existent or self-imposed.
Justice Curran, that is absolutely...
Can I ask a question, however? I believe that the judge, I realize, precluded it, but at the same time, she mentioned it in her decision. Is that correct? So it appears that she took that into account regardless.
Well, Your Honor, I think that there's a... Justice Smith, thank you. I think a distinction needs to be made between addressing it in the closing brief and whether or not she considered it on a full record. Now, the standard here is, we give deference to the trial court, if there's a fair interpretation of the evidence. There's no doubt from the record that she precluded the evidence, and though she mentioned it, She mentioned it in terms of coloring the credibility of Benvenuti, which I think was unfair under the circumstances, based on the fact that, she actually says in her decision that they chose to live together. And there's nowhere in the record that says that they chose to live together. They were, Benvenuti testifies that they were placed together because they spoke the same language.
Okay, I think we understand that.
Okay.
But you I think would acknowledge maybe that the standard here of review with respect to evidentiary errors is abuse of discretion. So we're not really looking at the weight of the evidence, because I don't see you arguing that. I think what you've argued is that there were so many evidentiary errors that we should reverse and give you a new trial. That's how I understand your argument.
Well, Your Honor, I believe that the standard, I think that the standard can be a little bit lower, and in the Moriarty case, Moriami case, excuse me, as well as its sister case in the Second Department, which was Appleton, where evidence is material and necessary, and the probative value outweighs the prejudice, then it's reversible error.
Based on an evidentiary error.
Correct, and this is, and both of those, please forgive me for interrupting.
No problem, no problem.
And both of those cases dealt with the exact same issue, which was preclusion of notice evidence in that regard.
Okay, I think we have that.
Okay.
Anything further?
Your Honor, if I can just cover very quickly the top serious accident report. It's black letter law that remedial measures is not dispositive. That if there is another permissible use, credibility being one of them, which appellant argued on the record that's what the accident report was being used for. The accident report should have been submitted and considered. That contradictory evidence would have called into question Top City's credibility rather than unduly prejudicing Benvenuti's testimony, and that could have led to an opposite result.
Anything further?
Your Honor, I think I can rest on my brief with regard to the opening the door, but I think that one thing that does bear mentioning is the fact that the evidence was unduly narrowed by this court, limiting things to affidavit.
Not by this court.
That is true, Your Honor. Please forgive me. By the trial court. Justice Smith, my apologies. No, you knocked me off my game.
Sorry.
No, the evidence was unduly limited to affidavits. There's nothing in law, in fact, that requires limited use affidavits, especially where there's no deposition, to be the full extent of the testimony, either an expert or in fact. And I think that that's worth mentioning, both as it relates to James Arose and as it relates to Benvenuti. They clearly, Mr. Thompson was clearly permitted to testify about things that Arose was precluded from testifying about, and as a result, that evidence should have been submitted.
Okay, anything further?
I think that that's it, Your Honor. I will rest on my brief as it goes forward.
Thank you.
Thank you.
Counsel, Your Honors, my name is Joe Rizzo. I represent the New York State Transportation Authority in this case. If I can shift a little bit to something that is not subject to this appeal. It was not contested by Mr. Saraiva in any way, and that's the testimony of Mr. Thompson. Mr. Thompson was the Transportation Authority's expert. He testified that he first differentiated between continuous electric current and status.
But if they haven't advanced as an element or a contention of error, do you want us to look at it anyways?
No, but I want, because it underscores the lack of credibility of the witnesses that he explained that the difference between continuous electric current and static charge. He said there was no conceivable way that this static charge could travel through Mr. Saraiva's body in the manner that it did. It simply was scientifically impossible.
But you're making a weight of the evidence argument. The way I read this appeal personally is that the points of contention are all matters of evidentiary rulings by this court, not weight of the evidence. There is a slight difference there, I think.
Understood,
The former is governed by an abuse of discretion standard, and as I understand it, they're arguing that the court made so many lack of discretion decisions that he should get a new trial. So the 3 points are Benvenuti, are Topsidis, and the expert, and I think you realize we know the record.
Yes.
What should we know on that, if I can direct your attention to those?
None of those three amounts to an abuse of discretion. Raul Benvenuti, to suggest that this is a discovery issue of a notice witness and that they didn't know that what he was going to testify to is ludicrous. The very first question that trial counsel asked Mr. Benvenuti at page 106 of the record is, now there were 2 incidents, weren't there, that you experienced on this job? They were fully aware that there was a second incident that they did not disclose, not as a matter of discovery under 31.
Wait a second.
Yeah.
You knew about this witness since 2017. He was disclosed. That's what the record reveals, whether it was in the bill or other disclosure, and you didn't depose the person. But your point, I think, among others, as our presiding justice said a second ago, that even if the court sustained the objection to this notice, this extra notice, the court seems to have considered it, and even if the court considered it, as it seems to have, it found that witness to be incredible.
Exactly. I mean, Judge Martin, without a doubt, considered the full length and breadth of Mr. Benvenuti's testimony, regardless of the motion to strike.
And I don't want plaintiff or anybody to misunderstand. I'm not making the argument for you. I just want you to know that this panel has a good grip on the evidentiary issues that are being argued as points of error.
Right. Okay.
Do you have something further?
No, Your Honor, unless there's specific questions.
Thank you.
Okay, thank you.
864, Joseph Dearsome versus Ontario Insurance Company.
May it please the Court, good morning, Your Honors. David Goodman appearing on behalf of the plaintiff appellant. Judges, this is a case about failing to meet a burden and burden shifting. This is a 3211A1 motion, A5 motion, so it's pre-answer, pre-discovery. And I believe the matter should be remanded back to the trial court. I'll give you 3 reasons why, and then I'll get into each one. So to summarize...
Mr. Goodman, if I can interrupt you real quick, and don't lose your place.
No.
But I'm looking at the record on appeal, and I see there's an affidavit from your client where she says at paragraph 14, page 92, "One Ontario sent me the letter dated June 17, 2021, referenced in Ontario's motion. It did not include a blank proof of loss form." That's the question of fact that I'm focusing on. Am I focusing on the right question of fact?
That is the exact question of fact that's raised under Insurance Law 3407A, and that is the exact reason I would submit to you, Your Honor, that this matter should be remanded back, because there is a question of fact.
And there's nothing in this record that shows that that blank form was included, correct?
That's correct. When we look at the email from, I always forget her name, Jillian Sherwin, there's no little paper clip. I call it Clippy, but there's no little paper clip there. There's other emails that show proof of an attachment. This one does not show proof of an attachment. I think therein lies the...
That's demonstrated by the plaintiff's email back to the insurance company showing the PDFs, 3 PDFs that were attached.
Correct. I think that's shown by that. I think it's also shown by what is their burden. They need to, in their moving papers, show that it was attached. And if you look at the Sherwin, I think it's Exhibit B, Record 7273, it's not there. And so because it's not there, the 3407A standard is not met, takes us back to 3211. The record is not made. There is a case that came down from this court back in June. It was the Bain case, Judge Montour, you were on that panel, that gave us the standard for 3211. I don't need to read it to you, but which is why I'm not. Because I don't need to. You know the standard already.
And And again, the only documentary evidence is this initial email from Ms. Sherlin.
Sure. That's the only documentary evidence because the Thompson affidavit cannot be the documentary evidence under a 3211A1 motion.
She was not present. She
was
was available. You know, she's not the one who sent the email. But with respect to that documentary evidence, this isn't the responsibility of your opponents then to show that documentary evidence utterly disputes the fact that, any other fact, that the document itself speaks that the profit or loss statement was included.
And because they failed to meet that burden, Your Honor, I submit we should go back for at least limited discovery on those issues, right?
I think we have your argument. Thank you.
Thank you, Judge.
May it please the court, Mark Whitford from Barclay Denman on behalf of Ontario Insurance Company. The court understands the issue. The issue is whether or not the blank forms were enclosed with the email that was sent. In respect to our motion, we submitted the email that indicated the blank form was attached. We sent the letter which indicated that the blank form was attached. The plaintiff ultimately sent back the filed proofs of loss with the same blank form that we sent to her when the proof of loss was sent to her. The issue of whether or not the blank form was attached was raised for the first time 2 years after it was sent, and it was only raised in opposition to our initial motion. We indicated in our reply, Your Honor, we have the native email. We have the native email indicating that the blank form is attached. We offered it to the trial court. If counsel didn't have it, we could provide it. It exists. It confirms that the blank form was attached. Again, the only reason it was not submitted, it's a native email. We're trying to identify what the actual attachments. It was only because this was raised for the first time in opposition 2 years after the form was sent.
Which is when it matters most.
Well, understood. And that is why we offered the native email. We have it. I certainly, if this court decided to send it back down, it would be a very limited issue. We would produce the native email, which establishes the blank form.
Otherwise, we'd have to hold that what's in that paragraph 14 is incredible as a matter of law, and we have to disregard it. That's a tough standard to meet, as you know.
It is, Your Honor, but I think the trial court did that here because there were so many incredible things stated by the plaintiff. She made lots of points, including, most notably, that she didn't even know about a deadline when she had actually asked for an extension of the deadline. She indicated that there was computer issues.
We understand that.
There was a number of issues. That's why the court reached that standard and ultimately determined to grant our motion.
Thank
If
you.
nothing further, thank you, Your Honor.
866 Rumsey Fall LLC versus Peter Purcelli. Morning, just a second, please. There we go. Good morning.
Okay. All set?
Go ahead.
Good morning, and may it please the court, Thamel Bovey Jr. for the petitioner appellant Rumsey Fall LLC. Should this court determine the administrative appeal filed with the ZBA on November 14, 2022, 20 days after an October 25th, 2022 HBC decision on the record was untimely? We say the answer is yes. And should the court vacate that December 22nd, 2022 ZBA decision as a result? Because the ZBA had no jurisdiction. We say the answer to that is yes. So this proceeding, this administrative appeal was untimely because there's a uniquely worded 15-day time limit in section 173.10 of the Town Historic Preservation Chapter. It merely requires appeals to be filed within 15 days of the HBC decision. It does not say 15 days after the decision is filed. It does not say 15 days after a written decision is issued. So there's no requirement in the town code regarding filing or decision. So this is different from the myriad of cases interpreting town law section 267A with its requirement of filing zoning officers filing decisions and then appeals, time limit starting when the decision. So some interesting facts that we'd like to draw your attention to. The Bailey was at the ZBA decision on October 25th.
Counselor, I have a question for you. You're going back to the ZBA, correct?
I'm sorry.
The court's
I'm
decision?
sorry. Thank you, Your Honor. He was present at the HPC decision on October 25th. He actually asked the HPC to deny so he could appeal. So it's pretty clear he was aware of the right to appeal. He was informed of the decision under the set up with the
Counselor, excuse me, Counselor, can you hear me okay?
Yes, I can.
Just following up on Justice Kane's question, as I understand the order on appeal, the determination of the ZBA was annulled. Therefore, you won. Therefore, one could argue you are not aggrieved by this decision because, as Justice Kane pointed out a second ago, you're going back to the ZBA. So I think there's this substantial question about whether or not you're even aggrieved because that determination was annulled per Supreme Court's decision of September 8, 2023. Do you agree?
Well, I'm not sure I agree. Perhaps if that's the language in the decision, we're have to abide by it. But going to Rumsey Fall, going back to the Zoning Board of Appeals raises a whole series of issues. They got this wrong once. We're concerned they'll get it wrong again, and there'll be more litigation. So we think we have standing. We think that the decision should have been vacated, and it should not go back to the Zoning Board of Appeals.
Okay, we'll look at that. Thank you.
So we'll submit on the brief on that issue. We'll also submit on the second argument concerning exhaustion of administrative remedies. Thank you.
Thank you.
Thank you.
Go ahead.
Good afternoon or good morning. Mark Romanowski here for the Town of Seneca Falls Heritage Preservation Commission. I won't belabor the points. I just want to follow up on the question of Justice Curran, and the real issue is about jurisdiction. So while the lower court annulled the decision of the ZBA, it would retain jurisdiction over the matter. The reason we're appealing the issue of whether or not the appeal by the original applicant to the ZBA was timely is because it's a jurisdictional question, Your Honor. So if this court were to agree with us that the appeal by the applicant was untimely, the ZBA doesn't have any jurisdiction at all. Annulling the decision would allow the ZBA to go back and review this matter again, as Mr. Bove pointed out, and we have no faith that the ZBA would reach an appropriate decision.
And Mr. Romanowski, again, following up on Justice Kane's question, all of that can be argued to the ZBA again, right, based on the annulment?
That they don't have timely, well, it's interesting, Your Honor, because in the record, the ZBA itself recognized the first time go through that, maybe this wasn't timely, but ultimately it's for the courts to determine when there's a question of jurisdiction. We don't, again, trust the ZBA is going to get it right, and it's really not their purview to decide whether or not they have jurisdiction. That's what the courts are for, and that's what Article 78 are for.
So you're both arguing you have no confidence in the ZBA getting a decision right?
Did you pick that up, Your Honor? Yeah, maybe.
Agree on something.
Thank you.
Thank you, Your Honor.
866.1, Colleen Hoffman versus St. Bonaventure University. We had you. Where'd you go? Hello. Good morning.
Good morning, Your Honor.
Go ahead.
Thank you, Your Honor. May it please the court, Steve Sharkey on behalf of the appellant, St. Bonaventure University. Your Honor, this boils down to a fairly discrete issue, and that is whether or not St. Bonaventure's stated legitimate, non-discriminatory reasons for choosing Dr. Hilmy over the plaintiff for this interim acting provost position back in 2021 was pretextual in nature, and that its reasons were false, and that the real reason for choosing him over her was on the basis of her sex and or religion. The answer to that, we would submit to the court, is a resounding no. The court below largely focused on these comments that were contained in a panel of interviewers comprised of senior executives and some faculty members who had interviewed the candidates prior to the decision being made by the then senior individual at St. Bonaventure, Dr. Zimmer, who ultimately was in charge of that. Your Honor, we don't believe that was correct. We believe it was erroneous to have found that questions of fact existed based on those comments for several reasons. First of all, he didn't particularly cite what the comments were, but in other portions of the decision, he referenced some comments that were made about a lawsuit, a quote-unquote lawsuit. I'd submit to Your Honors that nothing contained in those comments, or frankly anywhere else in the record, in any way raised a question of fact with regard to the only claims at issue in this case. The only claims at issue in this case, and that is that St. Bonaventure discriminated against plaintiff based on her sex and or religion. These comments about these quote-unquote lawsuit, we don't even know what that was, for starters, Your Honor. There's no evidence of that in the lawsuit, but we would submit that it's not germane to the actual claims that are at issue. What you won't find in the comments or anywhere else is any reference to plaintiff's gender or her religion or anything of that nature, which is really the only relevant inquiry on this motion, Your Honor. I know plaintiff has indicated in the brief she cites to these comments as well, but nowhere does she cite any specific comments that bear on it, nor did the court, because I won't find any. So I certainly encourage the court to look at that. I challenge plaintiff to point out anything in there that suggested that, but we don't believe there was anything that even gave a whiff. The reason this decision was made was because of her gender and or sex. Secondly, Your Honor, Your Honors, the comments themselves, they were made by individuals who were not even making the decision. The ultimate decision was being made by Dr. Zimmer. They were not decision makers. They were merely providing input to him. And therefore, there's a long line of cases, we've cited them, that comments, particularly scattered comments like of that nature, do not.
Even, let's go further than this. Even if initially that the plaintiff has made a case out here, then you come back and you say, look, we've got these legitimate reasons. We've got the survey that they went through. We have the experience of the other candidate, correct? And you've given discriminatory reasons for the decision. So you feel you've met your burden?
100%, Your Honor. I think the court below found as much, because he indicated that, where he was saying that they had raised the question of fact on pretext, which necessarily means we met our initial burden. And we don't believe there has been anything that raised the question of pretext. Your Honor, and just the third point on the comments I would make is that, as I mentioned, the ultimate decision maker was Dr. Zimmer. And I encourage Your Honors to read his memorandum, which is not just some self-serving document that we produced.
Oh, we've read it. Don't worry.
This was contemporaneous with the decision. He lays out a number of credible, legitimate reasons. Essentially, Your Honors, they found them both qualified. I don't think there's any dispute about that. They both had a number of good qualities, but ultimately they decided.
We understand. That's what I was just getting at.
Very good. Thank you. There's not much I need to add on that, Your Honor. The only thing I will add is plaintiff in her opposition brief also raised these comments and events from back in 2012 where there was some exchange with some prior officials in the administration. We think those are easily dispensed with. First of all, they involved individuals who had nothing to do with this decision-making process. In fact, as we point out in our papers, they weren't even affiliated with the university at the time this decision was made. So certainly no discriminatory intent can be inferred from those actions with respect to this decision. Secondly, there's a 9-year gap here between those events.
We understand that.
Okay, very good. And Your Honor, just further, I just point out the court itself below had previously found that they were too attenuated to infer discriminatory intent. So we believe it's law of the case. So unless the court has any other questions, I am happy to rest.
Thank you.
Thank you.
Good morning, Your Honors.
Right.
Judge Plotz found that the St. Bonaventure themselves raised triable issues of fact that must, at this stage of summary judgment, be decided by a jury, not by a judge, not by argument of counsel. And, this stage of summary judgment, if inferences are not afforded to the plaintiff, as they must be, then whether or not the discrimination was pretextual or not will never be decided. And that's the crux of our case.
It's pretext.
Yes.
That, the inferences that from you argue in your brief, the facts that should be tried all have to do with the pretext.
Yeah, pretext, issues of intent, issues of credibility, those are all issues, genuine issues of fact for the jury.
So, and Ms. Court, just so I understand it, so
Yes.
even if we accept for the sake of argument that defendant met their burden to show a legitimate non-discriminatory reason for their actions, their employment action, you're saying they didn't overcome as a matter of law the issue of pretext?
Correct, Your Honor. I think it bears, just briefly, looking at the fact that how was the decision made? The search committee, which was comprised of management and deans, they did a rating, they did interviews, and then there was a memorandum that the final decision maker, Dr. Zimmer, the provost, made. In all of those documents, there were issues regarding past litigation. And why was that? That has to be, that has to be looked at, and the jury has to decide whether that was discriminatory. The first comment that Judge Plotz quoted talked about she had challenges and bad experiences in the past. What does that have to do with her promotion or the denial of promotion? They brought up the past, which is why we went back to 2012 and talked about how she was treated because she was Wiccan, how she had to sign a document to uphold Franciscan values. In fact, even in this decision for promotion, there was a comment, she didn't provide any examples of alignment with SBU Franciscan missions and values. Going back, that whole issue, when she was asked to sign a document, she said, what if I were Jewish? And they said, you wouldn't have had to sign it then. They have put together, they've brought the past litigation into a biased decision, which affected whether or not she was promoted. And
Counselor, what are the specific pretextual items that St. Bonaventure used to deny her that are in the record?
Well, in the record, we feel they were very negative about the fact that she had litigation in the past, that she went against the university, and therefore she wouldn't be good, the Board of Trustees wouldn't like her, she wouldn't be good representation of the university because she had gone public with her previous discrimination lawsuit. It was her past actions that created a huge pretext issue in the decision of whether or not she should have been promoted to acting provost, which we, which the jury would be able to decide, you
We'll
know.
look at that very carefully.
I'm sorry?
I will look at that very carefully.
Okay, thank you. I think I'll rest on my brief unless there's any further questions.
Thank you.
Thank you.